Hello friends, in the series on the income tax cases, today we will discuss a very important judgment of Teleperformance Global Services Private Limited versus Additional Commissioner of Income Tax. This case has been reported in 106 ITR Tribunal at page number 81 and the matter has been decided by Mumbai ITAT B bench and the date of the judgment is 24th March 2023. As all we know that transfer pricing issue is a very lengthy issue, a little bit different also, and in case of transfer pricing matters, both the assessee and the assessing officer has to read a lot of literature, has to do a lot of homework before passing the transfer pricing order and the final assessment order. So there is a provision in section 153 that in case of transfer pricing matters, the limitation period of passing the assessment orders will be a little bit higher. In the present case, the case was related to the assessment year 16-17 and according to section 153, with the extended period of limitation, the final date of passing the assessment order was 31st December 2019. This date is important. In this case, the facts are more important. Section 92CA, subsection 3A says that in case of transfer pricing matters, the transfer pricing order should be passed before 60 days, 1 day prior to the date of passing the final assessment order. The date of passing the final assessment order was 31st December 2019. 1 day prior means 30th December 2019 and 60 days from there expires on 31st October 2019. So in this case, when the transfer pricing order was made on 1st November 2019 and accordingly the draft assessment order and final assessment order was passed, it was the point of the assessing officer before the ITAT that the transfer pricing order is barred by limitation because it has been passed on 1st November 2019 in spite of 31st October 2019. Mumbai ITAT, after analyzing all the facts, said that in this case for the assessment year 16-17, the date of final assessment order was 31st December 2019. 31st December 2019 was the last date on which the assessment order is to be passed. That was the limitation period. So 60 days prior to 1 day before that last date was expiring on 31st October 2019 and the transfer pricing order was passed on 1st November 2019. So the ITAT held that in case of in this case, the transfer pricing order is barred by limitation by 1 day and it is void ab initio. Now the question comes for the draft assessment order and final assessment order. So it was the point of the ITAT that if the transfer pricing order will be barred by limitation, then the AO will not get the benefit of extended period of limitation provided under section 153 and consequently the draft assessment order and the subsequent proceedings are also time barred. So friends, in this case, the whole matter went into the favor of the assessee only because the transfer pricing officer delayed the transfer pricing order by 1 day. So he didn't get the benefit of section 153 of the extended period of passing the assessment order. So in this case, the transfer pricing order, the draft assessment order, the final assessment order were all barred by limitation. Friends, this case is very important because whenever the assessment orders are passed, notices are issued, we have to see that whether they were issued within the limitation period or not. If they are delayed even by 1 minute, then they will be time barred. At the end of this video, once again, I am repeating the name of the case. The name of the case is TELEPERFORMANCE Global Services Private Limited versus Additional Commissioner of Income Tax, and this case has been reported in 106 ITR Tribunal page number 81. The matter has been decided by Mumbai ITAT B bench and the date of the judgment is 24th March 2023.